rolling back fair dealing would be disastrous for education. The Supreme Court of Canada has repeatedly articulated that copyright is designed to serve the broader public interest, which is best served by balancing both creator rights and users' rights.
Hey there, and welcome back to your source for everything and anything public education in Canada. I'm Andrew King, CTFFCA Director of Public Affairs. Thanks for joining me for my conversation with Michael Geist. For many in Canada, the topic of copyright is elusive and downright confusing. For some of a certain age, copyright became a major topic of interest as music moved to digital platforms and free downloading and sharing caused upheaval across traditional industries, from music to film and publishing. That digital trend hasn't slowed. In education, the pull and tug over what educators can use without paying licensing fees, known as fair dealing, continues to be fought by publishers and authors, despite Supreme Court rulings. Recently, copyright protection was extended from 50 years to 70 years after the death of an artist. This means that protected materials won't enter the public domain for an additional 20 years. This decision is seen by many as a win for publishers and a new challenge for educators struggling to find accessible and affordable lesson materials. Michael Geist, professor of law at the University of Ottawa and Canada Research Chair in Internet and E-commerce Law, and to many, a celebrity in the copyright world, joins me to talk about fair dealing, what's at stake for education, and perhaps the biggest threat to traditional copyright rules. Be sure to check out Michael's own podcast, Law Bites. In the meantime, please enjoy. Michael Geist, thank you very much for joining us today and tackling the issue of copyright. I think it's a major issue for education and for the Canadian Teachers Federation, but it isn't that well understood by many teachers across the country, even our member organizations. It is seen often as a bit of a niche topic, but one that's incredibly important. Now, I don't want to go too far into history, but going back 10 years, 2012, and many educators around the country thought that fair dealing was a settled issue, that educators had the right to copy, to a certain extent, materials to assist in teaching and learning. 10 years later, we're seeing this is starting to become undone. What's happening here, and have educators become maybe a little too comfortable as others have pursued changing the agenda?
Yeah, so great questions. And let me start just by thanking you for having me on the podcast. Copyright's one of those issues I love talking about. So really happy to have the chance to come on and talk about it. And I would say that in response to your question, for those educators that 10 years ago looked at the copyright landscape and thought this was a settled issue, I think they were right. I think 10 years later, it is a settled issue. And in fact, we could go back pretty much even 10 years before that, and it was pretty much a settled issue. Not quite 10 years, but if we went back at least to 2004, so 8 years before that in the CCH case, we are closing in now on 20 years of Supreme Court of Canada decisions, legislative reform that have made clear that fair dealing is a user's right, that those rights provide clear permission for educators certainly to make appropriate use of materials, and that, to the extent to which there was any doubt about this, the government included another clear exception within the Copyright Act to cover education, but quite frankly, that was evolutionary rather than revolutionary. So those that are comfortable or have become comfortable with the state of the law, I think that frankly reflects what our legislation says and what our Supreme Court of Canada has had to say. Why is this emerged as an issue again? And I agree with you, it is fast becoming an issue again. And that is because there are certain groups that have been very vocal, who have argued that somehow they've been mistreated by this, they've lost revenue by this, and have been urging, lobbying the government to essentially roll back what it did, but even more what the Supreme Court of Canada has had to say about this issue in a repeated number of cases. It's important to recognize, we can get into this. This has been litigated on multiple occasions at the Supreme Court of Canada. The courts come out the same way every single time.
Looking at this, it's a contest of messaging. It's a bit of a propaganda war at this point it comes from the publisher's standpoint. What we're really seeing, and so if you could reflect on this, it's the publishers pitting the artists, the authors, against educators and having the artists and the authors believe it's education that is cutting into their revenues when in fact the publishers are making billions of dollars in profit. How they get away with that sleight of hand?
Well, I think you're right to frame this as coming primarily from publishers and then copyright collectives like Access Copyright, who are the lead voices. And there's been an effort, obviously, to bring authors on board to try to carry that message. I guess the view is that it will be more persuasive with government officials if it's coming from authors. I think the sleight of hand, to the extent to which there is one, is that what has taken place has not been loss of or an ending of payments. So this is not about whether or not education pays for educational materials. They do in the billions of dollars. There is, though, or at least there has been over the last number of years as we've moved increasingly to a digital world, one in which we've seen a shift in who is being paid. And so education's paying. They now have, I think, a far wider range of choices in terms of how they can access those materials, especially when we're talking about digital materials, which now increasingly predominate within the education sphere. And so when you're an educational institution, you take a look at the options, you say, okay, I can now buy a license that gives me full digital access to these materials, that expressly permits me to take a portion of those materials and make them available to my students as part of the course materials that I need. Or I can pay a restrictive license to a copyright collective that doesn't give me many of those rights, doesn't give me that convenience. I think educational institutions, largely as public institutions using public dollars, take a look at this and say, well, I've got an obligation in terms of maximizing that public funding to ensure that it is used in the most effective fashion possible. They've got an obligation to the students to provide them with the best pedagogical experience possible. And they've got an obligation to the teachers to ensure that they give them as much flexibility as possible to give students the very best education they can. And it's pretty clear that that largely involves the kinds of digital licensing combined with some of what we see around fair dealing. And so, what the collectives who are pushing for just a single license, saying, no, 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 you still got to pay this license, are effectively doing is trying to drive us, I think, in many ways backwards. And really, the sleight of hand is in not acknowledging that there are payment for these materials. The difference is it's a different, in effect, intermediary that's being paid. And those payments, of course, should go on to the authors in much the same way they might have through a copyright collective.
But who controls that? If we were looking to get more money, more royalties to the authors themselves, where is that kink in this chain?
Well, if there is one, I think it is coming from the different kinds of intermediaries that are out there. So, education, in effect, is someone that's saying, okay, I'm going to pay licenses for different materials that I want to make use of. There are a number of different intermediaries that effectively bring together many of the materials that education might want to make use of and say, okay, you buy a license from us and we will give you access to these materials. And they may establish different kinds of terms under which these materials can be used. So it seems to me that what arises here is that for many years we had a single model, a copyright collective that said, okay, we are effectively representing many of those rights. What's happened over the last decade or more is these materials have become digitized is that there are now other intermediaries, database vendors and others that have also brought together many of these same materials in a single package and said, well, we can offer these to you as well. And here's what we're charging. Here's what you get out of it. And in many ways, you often will get more out of it than you might have gotten from the copyright collective. And so I think it's unsurprising that in a time of constrained budgets, a desire to maximize where the spending goes, educational institutions have looked at that, and the value proposition for digital licensing tends, frankly, to be far better. And so they go out, they license many of these materials, and then can make use of it in different ways. Now, sure, there were people that used to get a paycheck from or get a check from the copyright collective and say the size of that check is smaller now. Well, that's a function of licensing that's gone in a different direction, not an absence of licensing. I think it's also a function that as we move increasingly digital, we are in a better position to identify what materials are being used. And with all respect to many of the authors that have expressed concern, many of those authors are teaching themselves or are writing in relatively niche areas, English lit type areas, which I think are incredibly important and a core part of our culture, to be sure. They are not a core part of many of the curricula that we have within educational institutions. And so I'm often struck by this idea that, you get different authors saying, you're using my work and not paying for it. We today have a much better sense of whether their work is actually being used or not. In the past, they would be paid whether or not the materials were being used because they were part of this larger collective. As we shift to an increasingly digital world, we actually do know whether it's being used or not. And I think in many instances, it may not be used as much as some of those authors thought it was. It doesn't say that it isn't great work and it isn't important work. It's just not work that is actively being used. And the notion that we should burden students or educational institutions with having to pay for materials that they aren't using, especially during these difficult economic times, strikes me as what should be a non-starter.
So these are transactional licensing fees. That's how it's working now. If access copyright had its way and was able to bring back tariffs, is that even possible? Have we moved beyond that? Is this fight to bring tariffs back in? How does that work if we are going the digital route and going with the licensing fees? They're looking to double dip on that system. Is that what the argument is that they're making on the Hill?
I think in some ways, well, that's not the argument they're necessarily making. They wouldn't describe it as double dipping, but I do think that that is oftentimes what is in fact taking place.
Okay.
I sometimes think of this, and of course, there's no comparison in terms of the cultural relevance of works as compared to, let's say, a car rental, but it's somewhat similar in this sense, at least the licensing payment side here, where Access Copyright effectively says we're going to offer you some insurance to ensure that you're not violating or infringing anyone's copyright. Educational institutions are saying, okay, that's your insurance plan. I can get effectively similar or better insurance from database entities, from my analysis of the Copyright Act, from a range of different ways, from open access materials, a range of different sources that come together to satisfy my needs, and then individual transactional licenses where it hasn't been covered. When you go to rent a car, the car rental agency, of course, says much the same thing. Let me give you a insurance that will cover everything. If you had an unlimited budget, you might say, sure, why not? But for those that don't, they will often say, okay, well, you know what? I don't really need all of your insurance plan. Why? Because I actually have effectively paid for other insurance. I get it through my credit card, or I get it through my own auto insurance has me covered for these same things. So you have a range of choices of how to effectively insure. It's not about whether or not you take insurance. Everyone's going to take some form of insurance. It's what's the best, most efficient mechanism for doing so. And so we've seen this shift take place. And I think that if you're a copyright collective where the only thing, at least until recently, the only thing you have to sell is this insurance, is this license, it's not surprising that they will continue to fight to get people to pay for that license, even though the reality is they well know that educational institutions are paying for the underlying materials or are using those materials in a lawful fashion. It's just that they found alternative ways of doing so. And so long as there's appropriate distributions, let's say for the stuff that is licensed on the digital side, it seems to me that people are still, of course, being appropriately paid under those circumstances. And to the extent to which they're not, it's an issue with the new intermediaries who will have struck their own deals. It's not really an educational issue. The education side is to ensure they're operating within the law. And I think for the better part of certainly a decade since we saw the 2012 reforms, but I think we could go back even before that, they've been doing exactly that.
Now, as we look moving ahead, and like you mentioned, the lobbying efforts being made on Parliament Hill, what is the real risk that we take a step back? And why do they have the ear of people on Parliament Hill on this topic? When having this conversation, it seems quite evident and a very reasonable explanation as to why we're moving in this direction.
Yeah, no, well, I mean, I think there's a few reasons for that. First off, the risks, though. And I think the risks are enormous. We have seen the requests from some that are lobbying for change, and they would like to see a wholesale reversion on fair dealing. In fact, they'd go even further. They'd say, if we offer a license, we believe fair dealing shouldn't apply. Their view is effectively that your rights as a user, which the Supreme Court of Canada has repeatedly articulated, some of these rights under international copyright law for which Canada can't even derogate, their view would be, well, as long as we're offering something and there's the ability to pay us, we want it put into the law effectively that you got to pay us. Now, I'm sure there's lots of businesses that would like that kind of guarantee of payment, but that doesn't make it right. And I think in this instance, it's quite clearly not right. And it's more than that. It's wrong. It's wrong from a legal perspective. It is wrong from an ethical perspective in terms of the double payment. And it is wrong in terms of where that burden ultimately falls, because so often it falls on cash-strapped educational institutions or on the students themselves. And so this idea that somehow, well, it's just a cup of coffee or it's just this, it's just that, collectively, we are talking about huge sums of money, and it's coming out in some instances of some of the people who can least afford to pay it, especially when they are effectively, in many instances, already paying for it through these alternative licensing systems.
And we've seen over the past 2 years with the pandemic, the lockdowns, how many students have suffered as a result of that, their education. And taking a look at this is just another example of to strip something away, like you mentioned, from those who do need this access the most and aren't able to pay an extra fee. But what I keep questioning is whether that's a good enough argument to convince people downtown who obviously have the ears of some very wealthy publishers. I know that to access copyright's also looking and pushing for the federal government to establish new creators' digital rights. Would this encompass everything that we're talking about, or moving that in a completely new direction to reframe this whole conversation? It's the first question. And the second one is, what about the rights of educators and students and learners?
Right. Well, you know what? We have now in Canada spent the better part of almost 2 decades with the Supreme Court of Canada that has settled this issue, to come back to where we started. And they've made it clear repeatedly over the objections of some of the very groups that you just mentioned, over the doubts that have been thrown, initially saying, it was just obiter, which means it was just some extra commentary. It wasn't really legally binding. They've challenged it once, they've challenged it twice. Every time the Supreme Court of Canada comes back with the same answer. Copyright is designed to serve the broader public interest, which is best served by balancing both creator rights and users' rights. And where we move the needle too far in one direction or the other, we run the risk of losing that balance. And so when you ask, don't teachers and educators have rights? They absolutely do. The Supreme Court of Canada has made that abundantly clear, that these are users' rights, and that any attempt to limit some of those user rights has an impact on ensuring that you continue to strike that balance in the broader public interest. And so while you might go back decades to court cases that tried to frame the Copyright Act as being primarily about authors or creators, in Canada now, for the better part of 2 decades, have a system where the court has made it very clear that what the law really is about is serving the public interest through this balance. Now, you've asked the question, why is it that this is getting this airtime? And I think that at least part of it is that if you are a copyright collective and the only thing you have to sell is a copyright license, even one that at this time simply is just far less relevant than it once was. It used to be about photocopy machines. Photocopy machines are practically not used anymore. It used to be about the broad umbrella type collective license. And nowadays you've got competitors in effect that are offering up some of those same kind of licenses. It used to be about saying that you could restrict just about any use for teaching purposes. And the court has made it clear that, well, no, fair dealing covers many of that. It used to be that all the works are covered by licenses. And now we know that so many in many of the different fields that people study in are covered by open access licenses that allow for these works to be freely used. So the world has dramatically shifted, but it's tough to shift off that license if that's the only thing you have. And so the push has continued to be to sell and push and lobby on that license. If you're a teacher, you're focused on your students. You're focused in the last couple of years on how are you going to manage in this new hybrid environment? How are you going to deal with the COVID-related issues? How are you going to deal with the specific learning issues that invariably arise from this challenging environment? If you're a student, you're faced with real questions about how do you make ends meet in the current environment and all the other challenges you face. Copyright might be critically important to the kind of pedagogical experience that you're able to deliver as a teacher or to the learning experience that the student has. It might have a bottom line impact for the individual student, but you are faced with juggling so many other issues that, lobbying on copyright just is not going to be at the top of the list. And so in some ways, the fact that teachers and students have so many of these other issues to deal with, whereas if you are a copyright collective, this is your issue, has the effect, at least leading up to now, to essentially seed the field. That you don't get students and teachers spending their days on Parliament Hill lobbying members of Parliament. But that's precisely what you get from publishers and copyright collectives.
So I guess, again, looking forward, what's the smarter play here, to continue this argument that is out of date to a large extent, or to reframe this conversation on behalf of learners and teachers?
Well, I think at this time, we are facing those that are concerned with balanced copyright, with fairness within the law, with the interests of education more broadly. We are facing a bit of a steep hill to climb, in part because there has been, if we're honest about it, if not misinformation, at least a lack of information around the realities of what is taking place from a licensing perspective, around the realities of what's taking place more broadly in terms of where copyright is at. And so there are a generation of members of parliament who have been hearing just one side of the story, haven't heard enough from an education side. In my view, there is, at least hopefully, still some time in this regard. Members of parliament have kids in schools too. There are dozens of them who are in constituencies where there are universities and community colleges that directly affect the lives of thousands of people within their constituencies. The door needs to be open to hear those views. And I do believe that, much like the Supreme Court of Canada, which has, as we've been saying, been faced with these same questions on several occasions. Essentially, the door has been open a few times to say, are you sure you're getting this right? Is this really what you meant? We're going to give you another opportunity and yet another opportunity to kind of push back from where you were and to kind of recast or reframe. And in each instance, the Supreme Court of Canada has been given the evidence. They've had a chance to hear the arguments and said, well, no, this is how we read the law, and we are going to double down or triple down on many of those interpretations. I guess I remain somewhat hopeful that where members of parliament are presented with the realities, with the evidence, in effect, in much the same way that the Supreme Court has been, I remain somewhat optimistic, cautiously optimistic, I suppose, that in much the same way as Supreme Court of Canada judges, when presented with the actual evidence, with the actual facts, with where the law is at, have been absolutely consistent in their interpretations and their read of the current situation, that members of parliament, once presented with those facts, with those realities themselves, and we restore the balance in terms of the voices that they're hearing, as well as a balance to the discussion around these policies and legal issues, that they will recognize that, in fact, it's not broken. The system is not broken. That, in fact, there are payments for those that merit payments, that the law is being interpreted in a fair manner consistent with the Supreme Court of Canada. And while there are things that we would benefit from in terms of copyright reform, rolling back fair dealing or mandating license payments because a lobby group pushed you to do so without providing you with the full evidence would be disastrous for education. And, when you think of the inextricable link between education and the future economic and cultural success of the country, it would be disastrous public policy long-term for Canada.
Michael, I think I'll leave it there on that note of optimism as we look forward and continue the struggle that seems to come up time and time again, and we have to get everyone together and push back on this. Just wondering if you have anything else you'd like to add that I haven't touched upon that's burning in your mind.
No, I think you highlighted on just the same issues. I guess my only other point at this stage would be to say that I think we've identified the reality of the situation. There's no reason to sugarcoat it. The discussion on Parliament Hill has been dominated by one set of lobby groups. And it's a big ask to ask educators and students to sort of leave their day jobs and ensure that the policy frameworks and the discussions are fully representative of what the realities are. But there is a need, I think, for our educational institutions, for some of our teachers and students and leaders within that community to step up because, we teach the importance of people speaking out on core issues. This is an instance where we need, in effect, I think in many instances, to advocate for ourselves, because it's quite clear that the information that's being given to some elected officials doesn't provide a full representation of either of where the law is at or the realities of how education is already spending enormous sums of money, much of which ultimately goes to compensate creators and authors for their works.
Michael, thank you so much for this.
Oh, thanks so much for having me.
Thank you for joining us for this episode with Michael Geist. To learn more about fair dealing and how it affects publicly funded public education, check out the op-ed linked in the show notes. And thanks again for listening and tuning in to your source.